Violence often begins with a judgment clouded by chemicals, a sudden fracture of reality where perceived threats collide with drunken confusion. Consider a common legal problem. Gemma is highly intoxicated. She mistakenly believes her boyfriend is about to attack her, so she strikes him, fracturing his skull. She is charged under Section 18 of the Offenses Against the Person Act for causing grievous bodily harm with intent. A sober person who strikes back because of an honest mistake is usually acquitted. A drunken person who lacks the intent to cause harm is also acquitted of specific intent crimes. However, when a defendant tries to claim both, the legal rules collide. English criminal law is not built on pure logic. It is bounded by strict public policy, and the statutory rules governing this collision determine the difference between an acquittal and a conviction. Navigating this intersection requires a move past rote memorization and into the high-level policy critique that defines the most sophisticated legal analysis. Intoxication functions as a denial of the prosecution's ability to prove mens rea. It offers no justification for the underlying act itself. The case of R.V. Kingston proves that even involuntary intoxication provides no protection if the defendant still formed the intent to commit the crime. If the mens rea is present, the intoxication is legally irrelevant. When intoxication is voluntary, the law draws a sharp line between crimes of specific intent, which require purpose, and crimes of basic intent, which can be committed recklessly. This legal flowchart for intoxication shows the path from voluntary down to mens rea absent, reaching a critical junction. The result depends on the offense classification, leading to not guilty for specific intent, but guilty for basic intent. In DPP v. Majeski, the House of Lords established that the reckless act of getting voluntarily drunk supplies the necessary mens rea for basic intent crimes. This policy rests on Lord Birkenhead, who asserted a person voluntarily destroying their willpower should be situated no better than a sober man. Precision is vital here. Avoid the phrase, the defense of intoxication. The correct terminology is intoxication preventing the proof of specific intent. The Majeski rule acts as a policy barrier, ensuring that defendants cannot use self-induced states to escape liability for reckless violence. Self-defense operates differently. It is a true justification that, if proven, renders the Actus Reus lawful. It uses a two-tiered test. The first tier is subjective. The necessity of force is judged based on the facts as the defendant genuinely believed them to be. Under the common law precedent of R.V. Williams Gladstone, an honest belief protects the defendant even if that belief was unreasonable to a witness. This principle is now anchored in Section 76 of the Criminal Justice and Immigration Act 2008. The second tier is objective. Regardless of the defendant's belief, the amount of force they actually used must be reasonable and proportionate. In R.V. Clegg, soldiers fired at a car breaching a checkpoint. The initial shots were legitimate self-defense, but a final shot fired after the vehicle had passed was ruled excessive. That single act destroyed the entire defense. There is a significant exception to the proportionality rule for householders under Section 76(5)(a). Rulings in Collins and Ray clarify that within a dwelling, a householder can use disproportionate force, provided it is not grossly disproportionate. This system is designed to balance the subjective fear of a citizen with the objective need to prevent lawless retaliation. We arrive at the central question: what happens when a defendant's subjective mistake about needing self-defense is caused by their voluntary intoxication? The Court of Appeal addressed this in R.V. O'Grady, a ruling later codified in Section 76(5) of the 2008 Act. Section 76(5) explicitly prevents a defendant from relying on any mistaken belief if that mistake is attributable to voluntary intoxication. The law maintains this strict stance in assault cases, but a sharp divergence appears when the crime involves property. This figure compares the effect of intoxication on self-defense and lawful excuse. We contrast a defendant mistakenly believing they are under attack with one mistakenly believing a property owner would consent. Tracing the logic, the intoxicated mistake yields a guilty verdict for assault, but an acquittal for property damage. This asymmetry reveals the priority of the courts. Public policy will sacrifice logical consistency to ensure the law provides maximum protection for the human body. We can now resolve Gemma's case by applying these isolated rules. First, the Section 18 charge. Because this is a specific intent crime, Gemma's voluntary intoxication can be used to show she lacked the necessary intent to cause serious harm. She is acquitted of the Section 18 offense. Second, the lesser charge of Section 20. This is a basic intent crime. Under Majeski, her reckless intoxication supplies the mens rea. Finally, the self-defense claim. Because her mistaken belief that she was being attacked was induced by alcohol, Section 76(5) and O'Grady strip the defense away. The result is clear. Gemma's defenses fail, and she is guilty of a Section 20 assault. When analyzing these scenarios, always process intoxication and self-defense separately. Statutory public policy is the ultimate filter, and in the English courtroom, it will always override the logic of the intoxicated mind.